Good afternoon, everyone. Welcome. Thank you for joining us today. Allison Scoberg here with Consolidated Planning Group, and we are delighted to be back with the law firm Hayes and Wilson and Julia Hayes, more specifically. She's going to be talking to us today why my family needs incapacity planning. So she's going to take a deeper dive into that today. So I always like to start with a few housekeeping items first. If today is the first time you've ever joined any of our webinars, welcome. We're so glad you're here. If you've attended in the past, we are glad that you've come back. We are in webinar mode today, which means that we can't see you or hear you, but we know you're there and we're glad that you're here with us today. And we do invite you to put your questions in the chat box. Today we did have several write-in questions, and a lot of the write-in questions were really not relevant for today's topic. So I will have my staff reach out to you personally on those specific questions. We can definitely help on your SSI questions and kind of some of those benefit questions today. So, Consolidated Planning Group, we are a holistic special needs financial planning firm. We're nationally certified as Social Security advisors, members of the Special Needs Planning Academy, chartered special needs consultants. Our whole firm is nuanced in planning for a loved one with a disability, thinking about things about answering questions like who's going to care for my child when I'm gone, what happens after high school, what are higher education options, what are housing options in the future when I might be in a position where I can't care for them. How much money do I need to fund a special needs trust? And one thing that we always like to make clear, Julia, is the difference of what you guys do and what we do, because I think sometimes there's confusion of people thinking that you guys do everything that we do and that we do everything that you do. So there is a division on that. The truth is we work very closely with firms like Hayes and Wilson, and your planning documents, those legal documents. We're talking about trust, special needs trust, wills, powers of attorney, healthcare power of attorney, the legal documents, the legal side of things. That's going to be the law firm. We're the money. I like to say they're the paper, the legal documents. They're very, very necessary and very important, not a do-it-yourself project. You really want to work with a true professional, and certainly a true professional that is nuanced with special needs. And then we're the money. How much money do we need to fund the special needs trust? How and when should we apply for public benefits? What benefits might we qualify for? How do we have money in the right buckets to preserve the eligibility for such programs? So we really help with all of that. We do a lot of protection plans, lifetime care plans. We do transition planning. We help set up ABLE accounts, and we do a lot of advocacy by way of our webinars. In fact, we have the Consolidated Planning Group YouTube channel. There are over 500 webinars on planning for special needs. If you can think of a topic, we've probably done it. And you know, that channel was really born out of my own frustration. I am a parent to multiple children with disabilities, adult children that have transitioned into adulthood, and I do this. This is what I do. I know this stuff inside and out, up and down, and I thought it was hard. I thought it was hard when we were transitioning into adulthood, and everything that we do is so difficult, and how you feel nervous that you're going to accidentally mess something up that you don't know about. So that YouTube channel was born out of that, because we want to empower you, give you the tools and resources that you need to feel to be successful, so that way you don't feel defeated on this journey, because I know a lot of times often parents do. Fewer than 0.1% of all financial advisors in the U.S. focus on special needs. Now, while I don't know that specific number for attorneys, what I do know is that all attorneys are not created equally. And just because an attorney can do a special needs trust for you, that does not mean that they regularly do that. And we've seen some errors. We've seen a lot of firms needing to correct documents, when it comes to some of these things. And that is why we do also recommend that you do work with an attorney that is specifically nuanced for people with disabilities. We think that that is very important. So having said that, I want to jump right into our content today, Julia. Again, everybody is invited to put their questions in the chat box today. We've certainly partnered with Hayes and Wilson for webinars in the past. We've heard from Bill Hayes, where we had formerly heard from Lisa Wilson, and we've partnered with Julia several times. So Julia, tell us a little bit about you and your firm, and then we'll get right into the content.
Oh, well, thank you so much, Allison. Yeah, so happy to be here. So our firm does pretty much very narrow focus to the estates code. So that's planning on the front end, whether you have a special needs child or not. So wills, power of attorney, medical power of attorney, a lot of the documents I'm going to go over today. It's probate on the back end. So if someone passes away, whether they have a will, no will, we can handle that. And then a third of our practice is special needs planning. So Allison had mentioned a lot of people do special needs trusts. We do them very regularly. And so part of the special needs planning might be special needs trust. It could be guardianships. It could be mom and dad are getting older. And now what do we do to maintain their independence? And how do we protect them, even though they previously had capacity? And so that's going to be kind of the main focus today is not on our children, our grandchildren, our nieces and nephews with their own disabilities or special needs. It's what happens when we, the capacitated people, have an issue.
This is such an important topic, and I know that it's always top of mind, Julia, for our families on special needs trust, first party, third party, guardianship, and these are all topics that we've taken a deep dive with specifically with Hazen Wilson and other professionals as well on our YouTube channel. So if you're looking for that, just know that all the information you could possibly need is out there. But this is such an important topic here because so many times we're so focused, so narrowly focused on our loved one with a disability that some things slip through the cracks, and it also might slip through the cracks for our aging parents or our neurotypical kids that, we also send off to college and other things like that. So I'm excited for you to talk to us about this.
Yeah, thank you so much. And one of the things today will be a bit more personal than my previous presentations on this topic. So I give this topic presentation all the time. Anyone who comes into my office, I tell them, yes, we give care to the people we love, but also we have to put our own masks on first. And there is a chance that we could end up with an incapacity. And so we need to do this. Well, I'm now in the thick of it. So I personally have a family member who, I'll just tell you, it's my mom, had a very traumatic car accident on June 16th. And so this entire summer has been going through many of these documents. She has gone from ICU to life flight to another ICU to an LTAC, which is a long-term acute care hospital, to a rehab, to a skilled nursing facility. She is now home with care, but I have literally lived through all of this, and we're still dealing with it and still have a lot going on. So I'm going to go over several of these documents that I think are important that everybody have in place. So whether that's, us as parents, whether that's, as Allison alluded to, the kid going off to college, all of a sudden they're 18, you don't have a right to access their medical information. If they end up in a hospital for a car wreck, who's calling you? How do you know that this happened? And so having some of these documents in place can provide a framework. It's not going to solve every problem, but it provides a framework for who should be notified, who should step in and make decisions, what decisions should be made, what should be handled by which particular skill set. And so, I think when we do estate planning, everybody comes in and they know what a will is, or maybe they know what a trust is, and they say, when I die, here's what I want to happen to my stuff. Great. But you're not here for that. You don't really care because you're not there. But if you're alive and something happens to you, if you have a sudden onset disability, if perhaps you're sent overseas, you're in Dubai for 6 months for work, what happens? Who can take care of things? And so we look at this from the standpoint of two main sides. The financial side, which is who's going to manage your income and assets. Does someone have the authority to step in and call your insurance company, deal with your utilities, pay your bills, take care of real estate on your behalf? And then the other side is medical. So who can make medical decisions for you? Who can have access to your medical information? What decisions would you want them to make? So is there some level of quality of life that you would find acceptable? And at some point, would you say, enough's enough. I want to be allowed to pass away gently, or I want to be on life support forever. I want to continue this. I want to see if I can heal. So all of those decisions, if you can, to the extent possible, obviously we can't anticipate everything, but to the extent possible, make them ahead of time, you help take the emotional burden off of your family.
One question that comes up on a pretty regular basis, Julia, is what if there is nobody else? I have some people that'll say, I have other kids, but they're not really capable of handling the finances, or I don't feel comfortable for whatever reason. Or I've had people say, it's it. After us, it's it. I don't have any siblings. My parents are deceased. Um, and so, do you have any recommendations? And I know that's a twofold, both the financial and the medical. And I know that have been, I know that there's obviously a such thing as professional trustees and things like that. And I also have heard of care navigators where maybe you can hire a professional organization to be a navigator. But do you have any suggestions for people that might find themselves in that category right now?
Yeah, that's a great question, and it comes up quite often. You've got the only child of an only child. They don't have siblings, they don't have cousins. If something happens, they're it. And so i- it is something that we have to sit down and go through. Are you really the only person in this scenario? Do you have family friends that you trust well enough? So on the financial side, I often work with financial institutions that will serve as trustees. Some will even serve as an agent under a power of attorney. And so generally, if there is enough assets, you can find a corporate fiduciary who's willing to step in. The concern is when we're, sort of ordinary wealthy. So we've got enough to live off of, but not necessarily enough that Frost Bank wants to step in and manage the money. And so, yeah, I do look for people in your life who are trustworthy for something like guardianship of your child. So say you have minor children and you pass away, ideally it would be a family member, but otherwise I look for proximity. So do you have a family friend where their kids also go to the same school? Or something that, I mean, if both parents die, that's already disruptive for the children. But if they don't have to move cities, that's less disruptive. So we try to think of it from a standpoint of what are everybody's particular skill sets, but also what is the practical implication of naming this person. So if they're 8 states away, pretty easy to do online banking, pay online bills. That's not a problem. It's not so easy to be there in the hospital with you and sign consent forms and get your kids to soccer practice and all of those little practical things that we do every day. So yeah, I do look for, if not a family friend, then a professional. We've used care managers in the past, and they kind of aggregate your medical care. So they say, okay, we know you need a follow-up with the orthopedic specialist and the neurosurgeon, and how do we get those appointments made in the same day? Okay, that's helpful, but that's not necessarily a decision maker for you. So yeah, if you have that situation, I would suggest sitting down and let's talk, let's hash it out.
And one thing that I also wanted to say, because sometimes people are worried about their kid that may be placed at a residential living facility, that's one question to ask when you're kicking tires about that. And I know that we're not talking about that right now, but future living situations for your loved one with a disability, some places will take on guardianship of the person, some places will not. So asking about what happens when we're gone and that kind of thing and what they can and can't do, I think is an important conversation.
Yeah, and I will say that in our supplemental care trust, we do have a provision that the supplemental care trust can provide for payment to a care manager, a coordinator, even, guardian of the person if necessary. So if you need to hire a paid professional, at least you know that there's the funds there to do so. Okay, so on the screen, we've got various mechanisms for managing the financial sides of things. So you can have joint accounts, you can do this financial power of attorney that I'm calling statutory durable power of attorney. That's the technical term. Revocable living trust, supplemental care trusts, be the representative payee through various government programs. Usually we're talking about Social Security, but that's not the only program, guardianship. So all of that is how to manage the income and assets. And so if you can set these things up before you have an incapacitating event, then it makes a huge difference going forward. All right, so the first one is joint accounts. For most people who are in a partnered relationship, marriage, or otherwise, they might have an account that's a joint account, which means that two people have access to this account, or two or more people have access to this account right now. We're not waiting for an incapacity. It's either one of them can write a check on this account. And it's great for ongoing access to assets, ongoing needs. So you've got your electricity bill that comes out of that account, gets paid every month. If one of the joint account holders has an incapacity event, the other one can continue to direct that the payments be made, no problem. There's also the idea of a convenience signer. So a convenience signer doesn't own the account, but they are allowed to sign on that account. So that means they can also pay the bills and deal with anything that might come up regarding those assets, but they don't own them. If that convenience signer passes away, it doesn't go down the line to their heirs. It instead is still held by the owner. Now, we often have a well-meaning banker who says, okay, we've got a joint account, mom and daughter, daughter's helping paying mom's bills. Great, I'm going to go ahead and add a right of survivorship so you don't have to worry about the probate process. You just get the money when you pass. Well, that's great, except that I have two brothers. So if I'm a joint tenant with right of survivorship on an account with my mom and she passes away, my brothers might have some questions about why this money just went to me and didn't pass according to the terms of her will. Likewise, you have to watch out for something pay on death, which is cash, or transfer on death, stocks, bonds, securities, anything that passes the property outside of probate. A lot of times that's what we want, but just be aware of the well-meaning banker who, when you create a joint account, wants to go ahead and add these designations to that account. All right. So the big thing I'm going to talk about is the power of attorney. So most of us are familiar with a power of attorney. It does not take any power away from the principal, meaning you sign a power of attorney, you still have access to your own income and assets. You still have control of your own income and assets, and you can revoke or change this document at any time. But what you're doing is you're designating an agent who can act on your behalf. And so this person is a fiduciary. They owe you a duty. They owe a duty to not self-deal. They have to document any transactions they take using the power of attorney. We often have these documents go into effect immediately, so they don't require an incapacity event. I might just say, I'm going to be out of town, or I broke my femur, it's not easy for me to get around, so I want somebody else to be able to go to the bank for me, or I've got ALS and my speech is going, and cognitively I'm fine, but physically it's very difficult for me to make phone calls. My voice doesn't work as well. And so I want someone else who can act on my behalf. We typically recommend that you give pretty broad powers in this document. So we want your agent to be able to have the freedom to take care of whatever might come up, so they can handle all of these things for you. That said, be aware that this document then could be used as a tool for theft. So they have a duty to you, but that doesn't stop them from going and emptying your bank accounts. Now, you currently have capacity, you're awake to watch this person. If that happened, you're immediately going to take action to fix that. So I always say, if you can't trust someone when you're awake to watch them, if you're worried that they would go take actions now, then you shouldn't trust them when you're incapacitated. So I have a lot of clients who say, oh, I want this only to go into effect if I'm incapacitated. And, we have to delve into that. Like, why? Why wouldn't you want them to be able to act now? And if you don't trust them to act well now, then certainly don't name them.
Julia, sometimes we see parents getting a power of attorney and healthcare power of attorney signed by an adult child who doesn't have capacity. And I know that that kind of lends itself to guardianship, alternatives to guardianship, there's different alternatives. But the point of a power of attorney and the importance of that is the person does need to be of sound mind and understand what they're signing, have the capacity to understand what they're signing. Because, our 18-year-old kids will sign what we put in front of them, most of them.
Right.
But it doesn't mean that that was the right document. Could you just touch on that before we move on to the next one?
Yeah, absolutely. So it's not uncommon that we get a call and say, Mom's had a stroke and I need to get power of attorney over her so I can help her pay her bills. Well, at that point, we may not be able to have her sign something. So it looked like I just saw it very briefly pop up in the chat that Sharon asked the question of what's the threshold for capacity. The legal threshold is contractual capacity, which may not mean a lot to most of the people listening here, but that there is actually a specific legal threshold, is the threshold to sign a contract. And so if a person can just affix their name, that's not the same as understanding the implications of this document. So we do have to have kind of a minimum level threshold where they understand this is giving someone else access to my income and assets. This allows someone else to act on my behalf without necessarily consulting me. So they don't have to call and say, I'm using my power of attorney. Are you okay with this? And so if you've got a kiddo who's turned 18 and maybe can sign their name and read, but borderline on whether they understand the implications of naming someone as their agent, I would be a little hesitant to notarize that document. That said, it is a viable alternative to guardianship. So sometimes if a kid says, yeah, I understand this means dad can do things for me and I want him to help me pay my rent because sometimes I forget to pay my rent. Okay, that's enough that I would feel comfortable letting them sign it. But the person in question, the principal, has to make that decision and they have to appoint the agents. So dad doesn't get to decide who the agents are going to be or the alternate agents. The person signing it, the kid, you and me, has to be able to decide who their agents are.
And so I've heard some firms, use the, intellectual disability and IQ of 70 below. Somebody's saying 75 or below. But I think we've seen more, it's about the ability to understand. So a person may have a lower IQ, but also may understand. And what we've seen attorneys do is talk to the kid directly to determine. We've seen that and then provide guidance that way. Do
Right.
you
Yeah.
agree
And
with
so
that?
if there's a question, I will sometimes kick the parents out and talk to the kid directly. I like to do, and this is true for even my aging adult clients, I like to have two meetings. So I like to have an initial meeting where I find out what the person wants, draft the document, send the draft to them, and then have a second meeting where they come back and sign. And then the question is, do they remember what we're doing here? Do they remember who they appointed as the agent? And that particularly comes into play in situations with dementia or memory lapses. It's not that you have to remember the everything we talked about before, but you need to still have the same intent. This is still somebody you trust. And then a lot of times when I have, say, a neurotypical kid, but they're going off to college and the parents still want a little reassurance that they can step in and help that kid out if they need to, I will tell them, you can change this at any time. I will reiterate that fact. So in 5 years, if you're in a long-term relationship, if you're married, if you've got a good friend who you trust completely, you can change this. It doesn't have to be your parents. And that would be a great thing. Like the parents get a little nervous about that, but I'm like, no, that's showing their independence. All right, so up on the screen, we've got a whole list of the statutory powers given to the agent. These are what's included under the statute. So real property, dealing with business, dealing with banking, um, claims, litigation, tax matters, Social Security benefits, Medicaid, Medicare. I'm going to put a little caveat on Social Security, Medicare, Medicaid, and tax matters because the statutory durable power of attorney does not always work in those situations. So, Allison, if you could flip forward two slides, I believe. Yeah, oh, this is one. Limitations.
I
So,
just wanted to say too, that the Social Security Administration recognizes guardianship. The Social Security Administration absolutely does not recognize power of attorney. But
that's
there,
right.
even if you do not have guardianship, that's okay. But there are some special forms that you can have the person fill out, giving you authorizations to call on their behalf. And I'll put those forms in the chat box in just a moment. And then also, if you are a representative payee with the Social Security Administration, then clearly they'll talk to you. But I just want you guys to know they don't care that it's a legal document. They don't care that it's a power of attorney. It's not accepted. Guardianship is.
Yeah, that's exactly right. And so we've had a few instances where parents were frustrated because they were the agent under the power of attorney and they called Social Security, and Social Security's like, great, good for you. I don't have to talk to you. So, be aware that this document is not a silver bullet. It's very helpful, but it doesn't solve every problem. And then the IRS, they will accept this document, but then they will have the agent fill out their own document. Um, 2868, whatever it is. They have their own form. I can send it to you if you need it, of who can represent a client before the IRS. And then if you're a fiduciary, so meaning that you are an executor trustee in your official capacity, then there's a Form 56. So IRS has different forms depending on the situation. So I wouldn't necessarily assume that you can do everything with your power of attorney. And then there are some powers that are not included, but that we attorneys will draft in as additional, what we might call hot powers or extra powers, that although they're not included under the statute, we're allowed to draft in. So we can give your agent the power to change beneficiary designations, to make gifts, to establish certain types of trusts. You cannot give your agent under a power of attorney the power to make a will, to designate a guardian, to seek a divorce. So again, this is not a catch-all document. This is a very helpful document, but not a catch-all. And we often find that a third party might push back on accepting a power of attorney. They say, I don't know you. I don't know you from Adam. I want to talk to the principal. I want to talk to mom who made this power of attorney. And so then there are ways you can prove up the power of attorney, that it is still in force, that it has not been revoked, and that they should work with you. In my own situation, I have not had any problems with the financial power of attorney. I'm going to get to the medical power of attorney in just a second. But interestingly, with my mom, where she named me as the agent on both her financial and medical power of attorney, the medical power of attorney, the hospital seemed to be confused on whether they're supposed to listen to the spouse, the warm body that happens to be in the room that may or may not be related to the patient, or the agent under the power of attorney. Fortunately, in my family, we're all on the same page, and it really is any warm body in the room is able to make these decisions. But I could see where this could come into play later. So actually, since I brought it up, can we go ahead and flip through a few slides? So we'll come back to living trust, but I want to talk about the medical power of attorney because it came up. Keep going. It's probably like 2 more slides. There we go. Mechanisms for making medical decisions. So flip one more. Under the law, all of us have the right to make our own medical decisions. So unless you've been adjudicated to be incapacitated, which is guardianship, you have the right to make your own medical decisions, to consent to treatment, to refuse treatment. And that includes decisions about whether you want life-sustaining treatment. And so you have the right to admit yourself into hospice. You have the right to deny any treatment and say, I'm done. I understand that this is going to cause me to pass away, and I am electing not to receive this treatment. But there are a lot of situations where we don't have the capacity to do so. And so that could be you're unconscious. That could be you have dementia. There could even be situations where cognitively you may be able to make your own decision, but physically you can't advocate for yourself. You can't sign or indicate you can't communicate what your treatment decisions would be. And that would be where a medical surrogate would come in. So if you have done nothing, if you have no medical power of attorney, then the state does have a order in which people can consent to medical treatment. And I'm sorry because I'm looking at this on the screen and it is tiny, and I understand that you probably can't see that or read that. So I'll just go through it really quickly. So first it would be your spouse. And then it would be the adult child of the patient who has the waiver and consent of all other qualified adult children. I have never seen this happen. So I've never seen a situation where you've got one adult child that all the other children have said, you're the decision maker. I'm signing off on that. I don't know what the state of Texas was thinking there, because that they obviously haven't met families. That's not how the real world works. So then after that is a majority of the patient's reasonably available adult children. I don't know how they determine which children are reasonably available, then the patient's parents, and then an individual clearly identified to act by the patient before the patient became incapacitated, their nearest living relative, or a member of the clergy. So all of these people can consent to medical treatment, but whomever you've identified is going to be supposedly your decision maker. And so that would be where the medical power of attorney comes into play. So, and then it's Texas, so we also have certain limitations on what they can consent to. So you can consent to hospice, you can consent to withholding life-sustaining treatment, but you can't consent to voluntary inpatient mental health services. I don't know. That's just how the rules go. You can't consent to electroconvulsive therapy, and you cannot consent to an abortion. So
But the
keep all
medical
those.
professional, should a person be in psychosis or have serious mental issues, then the medical professionals have the ability to commit a person should they need to. The other thing I
Oh,
wanted to
yes.
say that you had mentioned, then your family gets along and everything's good, but not everybody gets along, and not all the siblings have the same opinions when mom or dad gets sick. And so that is one thing, like if you have more than one agent, I think you guys, I think you just got to look at things from a perspective of who has the ability to make tough decisions when the going gets tough, because it is tough at that point. And then not, considering wisely if you have a person that clearly couldn't make those decisions, and then also consider the possible potential conflicts with other kids or the people that you appoint, because I know that that can be an issue.
Yeah, no, that's a big issue. And so I often have clients ask me, can I name my two children as co-agents on a medical power of attorney? While legally valid, I don't think it is legally advisable or practically advisable. It's better to have order of priority. So your medical power of attorney agent should be the family discussion leader. I want them to include everyone. I want to get the perspective from your palliative care doctor, from their primary care physician, from the other siblings, anyone who wants to contribute to the conversation. But at the end of the day, um, so this is a quote from my mom, is lead, follow, or get out of the way. And so you need a leader, and the others need to understand that that person is in charge. And if they can't accept those decisions, they need to get out of the way. Because there are often times that we don't have the luxury of time where a decision needs to be made. Do we do the surgery, or do we take mom off life support? And so uh, picking somebody who has the emotional capability to make those decisions is huge. And that might not be the same person who could balance your checkbook and make the spreadsheet. They don't have to be the same agent as your agent under financial power of attorney. Certainly can be, but they don't have to be. And so one of the things that we recommend with the medical power of attorney is always a HIPAA authorization. So who can the medical professionals talk to? And sometimes on that, we make that a lot more expansive. So we want everybody in the family to be able to call and find out what's going on, but only this person is the final decision maker. Um, Now, when I do HIPAA authorizations for the grown kids going off to college, I do tell mom and dad, like, you need to respect your children's privacy. So do not just use this to check my chart every day. If they drank too much and ended up needing to go get medical treatment, be happy they went and sought medical treatment. If they went in and got an STD test, that's none of your business, right? Like they're doing the right thing by getting tested. Don't bring it up to them. Now, that's always obviously every family has different personal relationships and might be open to discussing these things, but that's not why your child's signing the HIPAA authorization. They're signing the HIPAA authorization so if they have a psychotic break, you can find out what's going on. If they ended up in a car wreck and they're in the hospital, you can find out what's going on. So I do give that caveat for in that particular circumstance. When it's your kid going off to college, you are trying to encourage their independence, please stop overbearing. But that's hard for us as parents. I personally am very much a helicopter mom, so I'm gonna have a problem with that, but we try.
Do you
Okay, so
suggest order of agents, SDPOA also?
I'm sorry, say that again.
The question in the chat box says, do you suggest order of agents, SDPOA?
Oh yeah, and the statutory durable, absolutely. So there I'm a little more comfortable with co-agents. There may be times when you've got, the one kiddo who works in the business with you and they're going to be boots on the ground, absolutely answering questions about what's going on with the business, but you want someone else to be able to handle, calling your insurance company or dealing with your utilities. So I am more comfortable with co-agents on the financial side than I am on the medical side.
Thank you.
But I do recommend having an alternate. So, I mean, if possible, and I know we don't always have that many people in our life, but if possible, have at least one alternate.
Do you want me to go backwards or forwards on your slides?
I want you to go forward. So I want actually you to go 2 slides forward to the directive to physicians. So I just talked about that HIPAA authorization. The other document that I recommend with your medical power of attorney is this directive to physicians. So sometimes it's called a living will. This is not a DNR. So you may have had a situation in your family where they have signed either an in-hospital or out-of-hospital DNR. A DNR is a do not resuscitate, meaning don't bring me back. If I collapse on the table, if I code, let me pass. If I develop pneumonia, I don't want antibiotics and ventilation. I just want to be allowed to pass. So directive to physicians is the situation where it's not emergency resuscitation. It's long-term life-sustaining treatment. And so generally, we talk about 2 scenarios. And this is a statutory form that can be tailored to your particular diagnosis, progression of illness, treatment options. But the statutory form goes through 2 different scenarios. The first is you have a terminal condition. So no matter what you do, you're expected to pass away within 6 months. That would be something like aggressive pancreatic cancer. It's not responding to immunotherapy. You are now at the point where you require life-sustaining treatment. So feeding tube, ventilator, artificial cardiac support, dialysis, whatever that system may be, where without that artificial intervention, you would be likely to pass away. And so you have 2 options: withhold life-sustaining treatment, which means just give you palliative comfort care and allow you to die as gently as possible, or do not withhold life-sustaining treatment, which means do whatever you can to prolong your life. And so you would indicate your treatment preference in the event that you're terminal. There's also another scenario where you have an irreversible condition. So that would be something like a vegetative state. You say, theoretically, they can keep me alive on life support for another 40 years, but it's irreversible. I'm unlikely to recover from this condition. So do I want to be allowed to die, or do I want to be kept on life support with maybe the intention that with research or stem cell therapy or some treatment in the future that you could recover from this. And so by making these selections, one, you're helping to reinforce that that decision is actually made for you, so your medical power of attorney knows what you want, but also you're taking the emotional burden off your family members. So they can say, oh, all right, I know what mom wants. And so in this situation, this document is helpful, but also helpful is having those difficult conversations. So we went through this. In my mom's car wreck, she had 15 broken bones. She had 4 arterial bleeds. The bleeds led to clotting and had 2 major strokes. So one in the brainstem, one in the cerebellum. So complete right side weakness at this point. she's not paralyzed, but uh, she cannot do anything but for herself on the right side. She can't roll herself. She can't move. She currently has a feeding tube. She had a ventilator. That's gone. We're off the vent now, so I'm really off the trach entirely. So she's breathing on her own. She did not have a stroke in the cognitive part of her brain, but she had to have a craniectomy, which removes part of your skull to let the pressure off so that she wouldn't stroke again. So there was a long time where she was in the hospital in the neurocritical ICU, unconscious, and the physicians there pulled us into several family meetings where we sat down and said, do you want to consider palliative care and hospice? Do you want to keep her on life support? And my mom had done a directive that said withhold life-sustaining treatment in the event of an irreversible condition. And my brothers pored over that document like it was going to tell them everything they needed to know about what my mom would believe was acceptable for her quality of life. And that was a difficult conversation to have. And it was one of those things where I said, well, we need to consider what that means. Like, what does it look like in the specifics for her? And so I asked her neurosurgeon, I said, is she going to be able to go watch my daughter play piano? Will she be able to watch my nephew play tennis? Will she do puzzles and participate in book club? Can she write? Which were those things that made her life more enriched. Those are the things she loves. In my mind, a physical disability would be acceptable to her. A mental or cognitive disability might not be. So if she couldn't communicate with us, if there was no chance that she would be able to participate in these activities with her grandchildren, I would say that she would say, let me go. And so we had really long, in-depth, painful family discussions about all of this. And at the end of the day, she didn't have brain death in the part of the brain that deals with communication and cognition. And so we did opt to keep her on life support for long enough to see if she was going to have some recovery from the stroke, which she has had. So, I mean, coming full circle on this, like she will always have a physical disability, but she can speak to us. She can tell us what's going on, maybe more than we even want to know. And so this document is hugely important, but I will always reiterate that those conversations are also important. There's only so much you can put in a statutory form. Allison, you popped on.
Yeah, I wanted to say that sometimes we see these forms where people haven't um checked the boxes or initialed where they needed to initial, which leaves it to interpretation, which is not good.
Sure.
So completing these forms completely, I think, is important. But I just wanted to say thank you for sharing your story. It's very personal, and but it's very real, and real things happen to real people. And so we really talk about not waiting until the crisis, till the emergency, till the accident, to the massive middle brain stroke that somebody didn't die from. We've seen it. I know you've seen it personally now, you've seen it all over your career. But don't wait until that moment where it's a day late and a dollar short. We've received the calls of I need a power of attorney, and my husband had a massive middle brain stroke and he didn't die, and he can't walk and he can't talk and he doesn't, I mean, he was completely incapacitated. There's nothing that he could sign. He couldn't move. So these are all very real things that can happen, and we don't think about it until something happens. So looking at these documents, making sure that you have these documents, dusting off your old documents that haven't been looked at 10 in the last 10 or 15 years, it's time to review them, because sometimes, even myself included, I've gone back and looked at my documents that I did 5 years ago, and we were laughing. We updated them in the last year and a half, and we were laughing at what some things we thought 5 years ago that we don't think now. So it is important to reevaluate that, and also the people that you've appointed, the people that you appointed 5 or 10 years ago. Some of them, we had a lady that passed away, um, and on her will, she had named more than anybody I'd ever seen, ten people And
Wow.
every single one of them were deceased when she
Oh
died,
my goodness.
except for one who was 96 years old with dementia. So anyway, it was a good thing. It would have been a good thing to update those documents and, have your people updated in line with your current views. So I just want to mention that. But thank you again, for sharing that. And do you want me to go backwards or forwards on?
You can just stay right here for a second. I was just going to finish up on the directives. Yeah, so this is an organic document. It's a living will. It can absolutely grow and change with you. And as I alluded to earlier, if you get a particular diagnosis, you might want to do a much more specific document. So, one of my partner Bill's ministries is that he's always worked with the Methodist ALS clinic. And so we do estate planning for patients of the ALS clinic and the Muscular Dystrophy Association. And they have a very specific prognosis that they are looking at, and they understand the progression of illness with ALS. And so, yes, this is a statutory form. It only does so much for us, but they can add whatever they want. And so we have a secondary directive that we do for patients with ALS that says, yes, I want to go on a feeding tube, but only in the short term, or yes, long-term feeding tube, or no, I don't ever want to go on a feeding tube. Same thing with ventilation. I want to go on feeding on ventilation in the short term. I'm okay with long-term ventilation forever, or I want to go on long-term ventilation and I want to become dependent on it so that at some point I can have the bodily autonomy to choose to go off of that ventilator. And so we don't have assisted suicide in this state, but it gives people the autonomy to make the decision of what is tolerable, what quality of life is acceptable for them. And so that's the difference in incapacity planning for ourselves as, presumably healthy neurotypical people, which always in question. But, we get to decide how much poking and prodding are we willing to put up with. Okay, so I can go forward with talking about guardianship. There's a lot of other financial options that I did not discuss before that I have slides on. Um, I was going to check the chat real fast because there were comments popping up quickly enough that I didn't see if there was anything
We don't have
specific.
any new
Okay,
questions right now. They were just thank you for sharing your story and that they had worked
you
with
guys are
you and they
very
appreciate
sweet.
it. So, and I would say like, on the like guardianship or other things like that, we do definitely take a deeper dive on that. So we've got about 13 minutes left for today. So go wherever you want to go.
All right, so then I'm going to have you flip back in my slides to the Revocable Living Trust because I think that this is a really good incapacity planning tool. Keep going, one more, I think. Keep going back one more slide. There we go. Okay, so this is a question I get quite often, which is, does my family need a living trust? And I think that there have been a lot of financial advisors, not necessarily Allison, but just who have presented that you must have a living trust, that there is no other option, that avoiding probate is the ultimate goal. We have to avoid probate because probate is the worst thing in the world. We are parents with children with disabilities. Probate is not the worst thing in the world. But probate in general in Texas is a fairly straightforward process. If somebody wants to do a will and not having a living trust or deal with the complexity of a living trust, I'm generally pretty comfortable with that. I recommend wills to most of my clients rather than a living trust. But there are a few situations where a living trust can be incredibly helpful. So one would be if you have assets in more states. So if you have assets outside of Texas, let's look at a living trust because we want to avoid probate in those other states where it might be more complicated than in Texas. But here, where I use the living trust the most would be in an anticipation of incapacity. So you come into my office and you say, I've just been diagnosed with early onset Alzheimer's. And right now I'm managing things, I'm taking care of things for myself. But I can see that at some point in the future, I'm going to need some help. I'm going to need someone else to step in for me. And I want to go ahead and empower that person now just in case my memory starts slipping, in case a scammer calls me. I want someone else who has the authority, the same authority as me, to manage my income and assets. So, a revocable trust is a trust that's established during your lifetime. It's not for the benefit of your children or someone else, it's for the benefit of you or you and your spouse. And so, it's holding assets during life. It does direct where those assets go at your death. During your lifetime, it can be amended, it can be revoked, you can change it. It doesn't have any tax consequences. So the IRS looks at that and says, it was your money before, you're benefiting from it now, you're still managing it. For all intents and purposes, that's all still you. So you still file income tax returns under your same social. You don't have to have a separate tax ID number. But it does allow somebody who can be appointed either as a co or successor trustee who has the same authority to access and manage your accounts, your income, your assets, whatever those assets may be. So a trust can hold anything that you and I can own. So it can have checking, savings, it could have a CD, investment accounts, real property, it could own shares of your LLC or your business. Anything that you can own, a trust can own. And so I find that if you have a incapacitating event or an anticipation, a known anticipation of incapacity, that a revocable living trust is really helpful. You do the work on the front end to get all of your assets retitled in the trust, and then it's all set up. It's ready to go. We don't have to rely on these third parties like the bank or the insurance company to look at your power of attorney and say, brother was on my form, or it wasn't signed within the last 2 years, or give me a certification that it hasn't been revoked. They'll come up with any excuse, right, to delay you using the power of attorney. Whereas if you are named as a co-trustee, they can't delay. They have to work with you. And so I find them to be really helpful from that standpoint. Allison, can you flip to the next slide? So these are some of the advantages that I've just gone over. Another big one is privacy. So for a living trust, there's no public filing of the document. When you die, your will is publicly filed in the county in which you lived, and the probate process is public. Now, we have mechanisms so we don't have to publicly file an inventory. There's an affidavit that we can do in lieu of an inventory. But still, I mean, a lot of people have concerns. I don't necessarily want all of my cousins to see what I'm leaving to my nieces and nephews, those kinds of things. And then because a trust is established during your lifetime and managed during your lifetime, you have a history of this is what I want. It's not a last minute will. And so it's harder to contest. Now, there are some misconceptions about living trusts. Allison, flip one more slide. And that is that you can get creditor protection for it. No, you can't. So as I said before, everybody looks at that and it's all still you. So state of Texas law says if it's your asset and you still have asset management control over it and access to it, we're going to still consider that you. You don't get creditor protection by putting it into a trust. In fact, self-settled asset protection trusts, which are sometimes favored under other states' laws, are disfavored under Texas laws. So you don't get creditor protection from your own trust. You can give your children creditor protection or some other third-party beneficiary creditor protection, but not yourself. Doesn't give you any
And
estate.
it, like in the example of giving that to your children, that would be an irrevocable trust, right? Um, uh,
That's right. Yeah, doing a trust for their benefit or a testamentary trust, something where it's outside of your hands now. It's given to them in this trust, in this instrument that you can't control and just take back.
so there's a lot of questions coming up in the chat box. Can you just put real property owned in another state in a revocable living trust?
Yeah, absolutely. So I often recommend that if you've got the Colorado vacation home, the California beach house, you can put a single piece of real property or multiple pieces of real property in a living trust in order to avoid probate in those particular states.
And including properties that people have properties inside of an LLC, because sometimes people have the LLC from a liability perspective. Is that correct, or how does that work?
You can put the shares of the LLC into the living trust, and then the LLC can own real property. So that's often something we see. Um, and
Okay.
then I see there's another question on a family trust.
Yes. I want to be
So
clear because most of the families here have kids with disabilities, that your living trust and your family trust is not a special needs trust, because sometimes we throw the word trust in there and we just automatically think that it would qualify as a special needs trust. And there are specifics that make a trust qualify or not qualify as a special needs trust, and they are not all created equally. So I just wanted to put that disclaimer in there because I think it's important that people know that.
yeah, that's absolutely right. So your family trust, your revocable living trust may create a special needs trust, which would be a third party supplemental care trust. Um, that's completely independent of your revocable trust. It's going to have different rules. It will have generally only one beneficiary, which is the person with special needs. So yeah, that's something that I could spend an entire hour talking about, special needs trust, and I'm sure that Allison has a program on that. But if you have a specific question, feel free to email me on that side.
Well, one thing on the family trust, Julia, like I think of like when trust might be appropriate is if you don't want to name beneficiaries outright, like maybe you have a kid who's not disabled, an adult who maybe is not good with money. So maybe a trust spells out how and when they would get the money as opposed to a beneficiary designation, where it's leaving it directly to the kids and how they spend the money is up to them. Whereas we could have the beneficiary be a trust, and then the trust doles out the money as highlighted as the parents' wishes. So we have seen some people do things like that, and all states aren't created equally. So, we are talking about Texas being easy on probate. And I guess my question, Julia, on that, on Texas being easy from a probate perspective, has that historically always been that way? Or is that subject to change with changes in political climate and political offices and things like that?
Yeah, we've always historically had a fairly straightforward, easy probate process. I mean, theoretically, it it could change. It's under the estates code, so that is a law created by Congress. But the changes that we see or have seen recently, and this is not based on any political party. This is actually one of the areas, of the very few areas of the law where there's still some bipartisan agreement, has been to make the probate process more efficient, clearer, easier, protect the beneficiaries. So, we're not seeing proposed legislation that completely changes the way that the probate process happens. And I cannot imagine that we would ever end up with an estate tax in Texas. There's a federal estate tax, but we don't have one in Texas. So, but to address what you said before that, that a lot of times you want money to go into trust for the benefit of children, children being a class of individuals here, not an age, simply to give them some protection from themselves, to limit what uses they could have for that money, or to stretch out and make sure that money lasts for them. That can be done either through your living trust or your will. So your will can create another trust, can create a testamentary trust. So yeah, it gets confusing because you can have one trust pour into another trust. You could have a will that creates a trust. But once we spell it all out, it works pretty seamlessly if everything's drafted correctly. Uh,
So I think like let's go over your key recommendations. We're about out of time for today, and I just want to say I know that there's been people in the chat box that say that they've worked with your firm or our firm, and we appreciate that. And I know that you guys offer consultations. So Hayes and Wilson is in the greater Houston area, and they do also help people online via Zoom meetings and other things like that. But let's hit on your key recommendations, and then I'm going to put your contact information in the chat box so people can reach out to you directly as well.
Thank you so much for that. Yeah, so key recommendations are essentially everything that I've already said, but documents that you can put in place to protect yourself and your family going forward in the event that you yourself become incapacitated. So I would say everybody should have a financial power of attorney and a medical power of attorney. Think about whether you would benefit from having a medical directive. If you have a medical directive, then you still have that responsibility to have a dialogue with your family regarding your plan for incapacity. How do we find these things? Where do you keep them in your house? Did you email a copy? How does your family members even know to look for this? And then also think about long-term care arrangements. So that might be financial arrangements. It also might be whether you would consider living in a group facility if you have family members at home who have the capability to take care of you, with the caveat that it is a big burden on family members, emotionally, physically. And then uh, again, where do people find this information? So a roadmap of last year's tax return, the title to the house, the title to the car. Where do they find it? You don't have to tell everybody you've got $1,000 in an account at Chase, but saying I have an account at Chase is really helpful. So making, and I don't care if it's a book, a spreadsheet, some sort of map for your executor, your agent or power of attorney, your medical power of attorney, so that they can find this information and then act accordingly on your wishes.
I just like to say a couple of things on long-term care. Long-term care, long-term care is not covered by traditional health insurance. It is also not covered by Medicare. So you have like up to 100 days with the first 20 being covered in a skilled nursing facility. They call a SNF for Medicare. But sometimes people erroneously think that long-term care is included in health insurance or Medicare, and it is not. So some veterans definitely do have long-term care coverage, but long-term care coverage is something outside of what you typically have. So it's important to look at that while you are of sound mind and body, that you could still make an informed decision to obtain long-term care coverage. And then the other thing that I wanted to mention, we don't run into this very often, but sometimes some of our aging parents, maybe somebody on here today, has a safety deposit box. And those can be hard because they find the key, but they don't know what bank it's at. The person's not on the bank, then they need a court order to get it open. So if you have a safety deposit box, tell somebody where it is, maybe put somebody else on there. You know, I don't know, you've got to make decisions on that, but it has been, I've had clients running around like a needle in the haystack, checking all the banks with a key, and it's not always great. So we see less of the safety deposit box nowadays, but just in case. And do you have any other suggestions on that, Julia?
Yeah, absolutely what you just said. Add a cosigner. So we hate having to get a court order to drill open the box. It's not as easy as you think it is, and it's a whole mess. So
It takes a
have,
lot more time, and then you drill open the box, and then there's one tarnished, not gold necklace in there, and there was nothing in there to begin with. And it was thousands of
right.
dollars of legal bills, a lot of effort back and forth with the bank and stress, and then there was exactly nothing in this. We are out of time for today. We've got Julia's contact information here on the screen. We're going to send you our contact information, our additional webinars, and we always offer free personalized consultations. So you guys will want to check that out. Everybody who registered here today is going to get a copy of today's slides and a link to our recording. That recording is also going to live on that Consolidated Planning Group YouTube channel. Again, if you had write-in questions that we didn't answer today, they weren't exactly for this topic, but we are going to reach out to you personally on that. So look out for that. And then please reach out to Hazen Wilson. You can talk to him deeper about your legal documents, about guardianship, alternatives to guardianship, and you will definitely be in the right place when it comes to Hazen Wilson. So thank you again, Julia. As always, it's certainly been a pleasure, and we look forward to partnering with you again soon. And thanks, everybody. Have a great afternoon.
Thank you so much.
Bye
Bye,
now.
y'all.